Hello viewers, you're welcome to my YouTube channel. As you all know, I am Tomilola Daniel, your real estate consultant and due diligent lawyer. So today I'm going to be speaking on the topic, notice to quit. Why did I decide to do this topic? I noticed that a lot of tenants go into panic mode when they get the notice to quit from their landlord or their landlord solicitors. Most of them do not know what to do. So today, I'm going to be enlightening you on what to do when you get a notice to quit. So first of all, what is a notice to quit? A notice to quit is a letter you get from your landlord or your landlord solicitors, making you know of their intentions that they want you to vacate their premises. So a notice to quit is a form or a type of statutory notice, and this notice to quit usually comes first before the 7 days notice of owner's intention to recover possession. And these are the two types of statutory notices under the tenancy law of Lagos State. So before your landlord tells you to vacate a premises or their premises, you are entitled to a notice. Now, the types of notice you are entitled to is dependent on the type of tenancy that you have. So if you are if you're a yearly tenant or a half-yearly tenant, it will determine the kind of notice that you will be served when your tenancy expires or when your landlord desires that you vacate their premises. So if you're a yearly tenant, you are entitled to a 6 months notice to quit. If you are a half-yearly tenant, you are entitled to a 3-month notice to quit. If you are a quarterly tenant, which means you pay your tenant or you pay your rent on a quarterly basis, you are entitled to a 3-month notice. If you are a monthly tenant, you are entitled to a monthly notice. So these are the types of notice to quit for every kind of tenancy that you may fall under. So it is after any of those types of tenancy that has been served on you that you will later on be served the 7 days notice after the notice to quit has elapsed. So when you're served a 7 days notice, it shows you that in few days time, your landlord is going to go before the court to institute a recovery of premises action against you. So what do you do when you receive a notice to quit? Before I go ahead, let me let you know that when you sign a tenancy agreement, the tenancy agreement that you sign or you execute with your landlord will dictate the kind of notice that will be served on you. So if in your tenancy agreement, your landlord states in the tenancy agreement and you agree to it that upon the expiration of your tenancy or upon the determination of your tenancy, your landlord should serve you a 7 days notice to quit, or rather a 7 days notice of owner's intention to recover possession. In such situation, when your tenancy is to be determined, you will no longer be entitled to normal notice to quit. Rather, your landlord will go ahead and serve you the 7 days notice of owner's intention to recover possession, because whatever agreement you sign with your landlord is binding on you. That is why I would always advise you that before you sign a tenancy agreement or execute a tenancy agreement, get a lawyer to review the tenancy agreement for you to explain explicitly the terms and conditions of the tenancy, so you do not in any way shoot yourself in the leg or sign what you do not understand. So after that has been dealt with, what do you do when you're served with a notice to quit? Why am I speaking on this? I noticed that several times when tenants are served a notice to quit, they always want to evade service. They do not want to acknowledge. They are weary of collecting the notice to quit, which invariably will be putting them on the disadvantage, because whether you receive or you accept that notice to quit or not, the law will still catch up with you, because it would not stop your landlord from going further to institute an action against you. And when it is said in court that one way or the other you try to evade service, or you prove difficult to the bailiff or to the lawyer that is serving you, it will put you on a disadvantage. Even before you go to court, it puts you on the bad book of your landlord. So what do you do when you're served with a notice to quit? Accept it and acknowledge it. When you have accepted and you have acknowledged, you can now open up a dialogue with your landlord. But before I go ahead into that, what some people would ask, or my viewers could be asking, or a curious tenant could be asking, why would my landlord want to serve me a quit notice or a notice to quit? Number one, your landlord may be serving you a notice to quit because they need their property or the demised premises for their personal use. Number two, your landlord may be serving you a notice to quit because you have breached a fundamental terms and condition in your agreement. Number three, it could be that your tenancy has expired. So whichever category you fall into, or whatever reasons it appears to be that your landlord is issuing you a notice to quit, accept and acknowledge the notice to quit. When you've accepted and acknowledged the notice to quit, open a dialogue with your landlord or your landlord solicitor, as the case may be. Now, when you open up a dialogue, try to find out why they are serving you a notice to quit. Then when you know the reason, whether it's for personal use or it's because you have breached a fundamental term or condition in the tenancy agreement. If it is because you have breached a term and condition in the tenancy agreement, I will advise you as a tenant, if you are not yet tired of the premises, that you open a dialogue and you remedy the breach of that condition or the breach of that term in the tenancy agreement. I believe that once you've been able to remedy this breach of the terms and condition in the tenancy agreement, things will be fine again between you and your landlord, or your property manager, or your landlord solicitor will know how to come in and mediate between you and your landlord. But in a situation where the landlord needs the property for its personal use, or your tenancy has expired and you are unable to renew, it is normal for you to still open a dialogue and explain your circumstance to your landlord or your landlord solicitor, and both parties can come to an agreement on the terms and mode of vacating the premise. So you could tell your landlord, okay, this is a 6-month notice. Okay, within so period and within certain period, I am going to vacate the premises. If you need an extension could be granted to you with an agreement between you and your landlord. So when you open a dialogue, it gives you an opportunity to have an amicable settlement with your landlord, and you would not be living in an hostile environment pending the time you are able to vacate your premise. So peradventure you are unable to come to an amicable settlement with your landlord, and it happens that you have to be in court. Being in court as a tenant is not a death sentence. Appear before the courts and state your circumstance. Fine, there are exceptional circumstances where we have very terrible tenants, or you could have very terrible landlord. Whichever your case is, appear before the court. Be responsible enough to appear at the court and explain your circumstance to the magistrate or the judge, as the case may be. Where the judge listens to your case or the magistrate listens to your case, they will be able to know the appropriate judgment to give you or give against you. But I need to say this, No matter how responsible a tenant is, no matter how good a tenant is, no matter how much you want to stay in a property, let me announce to you that the court will never force a willing tenant on an unwilling landlord. So where the landlord wants you out of their premise at all costs, the court will never give judgments in your favor telling you to stay in the premise. No way. That is never going to happen. So once a landlord has given you a notice to quit and you do not come to an amicable settlement, prepare to move out of the premises. Other situations that I've encountered when it comes to the service of a notice to quit is that most tenants have this notion that once they are served with a notice to quit, they are not obligated to pay the rent again. It is not legal. So if you're served with a notice to quit, whether a 6-month notice to quit or a 3-month notice to quit or a 2-month notice to quit, whatever the case may be, your landlord is still entitled to their rent for the number of months or period in which you are still residents in their property. In no way would your landlord be at a disadvantage to the extent that you as a tenant would not be paying the rent, except in very, very exceptional cases and where there are certain peculiarities that could arise. I also want you to know that before your tenancy expires, your landlord can issue you with a notice to quit. When it happens that your tenancy is yet to expire or is subsisting and your landlord issues you a notice to quit, I will advise you that in this circumstance, get a lawyer to weigh into your matter and open up a dialogue with your landlord so that perspectives can be properly aligned. If this video has been helpful for you, please kindly subscribe to my YouTube channel, click on the like button and share generously with your audience as I bring you another episode next week. Thank you.